Is timely justice a heart and soul of the Indian Constitution? I want to answer this question in the following ways. Our Indian Constitution is considered to be the mother of all statutes. We derive the entire nation functions under Indian Constitution. And the Constitution is broadly classified into legislature, executive, and judiciary. We know legislature has the power to legislate law for the welfare of human beings, living beings. Executives, one who executes those enacted laws for the welfare of the poor and people at large. Judiciary is the custodian of the Constitution. It keeps a check both on the legislature as well as on the executive to see the fundamental rights of the citizens and other statutory rights are protected. That is why Supreme Court is considered as a custodian of the Constitution. So with this understanding the judiciary and its effective position, let us understand what is the concept of justice that is enshrined in our Indian Constitution. Number one, let me take you to the preamble of our Constitution. What the preamble says? We, the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic, and republic, and state shall secure justice, most important. Justice. What sort of justice? Social justice, economic justice, and political justice. The concept of justice is based on the distributive justice. So now let us understand what is social justice. Social justice means doing greater good to the good number of people, to the people at large, at the same time without violating any of the accrued legal right with the individuals. Now, what is economic justice? Economic justice means that there should not be any inequalities among the people based on economy. Political justice, which gives equal opportunity and of status. So this is what the preamble says. And I would like to refer to Keshavananda Bharati case, which is popularly known as fundamental rights case or basic structure doctrine of basic structure case. In this case, the issue before the 13 judges bench is this: whether the Parliament can amend the Indian Constitution by virtue of Article 368. The judgment of the Supreme Court said, of course, Parliament can amend the Constitution under 368, but without disturbing the basic structure. Now, let me ask myself the question, what is basic structure? So the Supreme Court has sorted out what is basic structure is, and it is inclusive nature. It has not defined, it is of inclusive nature, depends upon the facts, case to case. The majority of the judgment said the objectives mentioned in the preamble is also a basic structure. So now we have seen justice, social, economic, political is the objectives mentioned in the preamble, and that preamble has become a basic structure of the Constitution as per A.P.Legal case. Now, moving on to the next article, Article 14. It guarantees right to equality before law and equal protection of law. Article 21, which guarantees you a right to life and personal liberty. So the importance of Article 14 and Article 21 can be understood by referring to one case, Hussain-era cartoon case. This case is otherwise called as right to speedy trial case. The facts of the case is this. Number of children, women and men, they were put in jail for number of years. One point is to be noted here. They were pre-trial prisoners. Trial is yet to commence. But they were languishing in jail for more number of years. It even went to the extent of exceeding the sentence which they could have got by their conviction. Therefore, the Supreme Court said, see, you cannot take somebody's personal liberty by putting him in jail for a number of years. This is absolutely a violation of Article 21 of personal liberty. And they said, you can take away personal liberty only by due procedure of law. And the due procedure should not be arbitrary, it should be fair, it should be reasonable, as held in the Menaka-Gandhi case. Therefore, in Hussain-era cartoon case, these prisoners' right, personal right, was taken away, and it's a clear violation of Article 21. Therefore, right to speedy trial has become one of the facets of Article 21. What is speedy trial means? Speedy trial will lead to speedy justice. And speedy justice is nothing but timely justice, which is a topic for discussion today. So that is how timely justice becomes a facet of Article 21. Now moving on to a very interesting article, that is Article 32. Article 32 is the most important article, and it is considered to be right to approach the Supreme Court or enforcement of fundamental right under Article 32 is itself a fundamental right. When Dr. B.R. Ambedkar was questioned that according to B.R. Ambedkar, which is the most important article, B.R. Ambedkar replied by saying that I can say Article 14 is important because I did not enjoy during my lifetime the equality. Or I can say Article 21 personal liberty and it guarantees life. But those articles become meaningless unless and until without a remedy provided under Article 32. So there should be a right and there should be an institution to provide remedy also. Therefore, according to Dr. B.R. Ambedkar, Article 32 is the heart and soul of the Constitution. So according to Dr. B.R. Ambedkar, judicial remedy is the heart and soul. Judicial remedy means the institution, the purpose of the institution, judiciary, is to render justice. Remedy, that is justice, to the litigants. Justice should not be a delayed justice, should be a timely justice. We all know a famous saying, justice delayed is justice denied. So I took the guidance from Dr. B.R. Ambedkar to choose today's topic. Is timely justice a heart and soul of the Constitution? I replaced timely justice in Article 32 because judicial remedy, the heart and soul. The purpose of judicial remedy is to render justice. Render justice should not be a delayed justice, should be a timely justice. Therefore, the birth of this topic has come from Article 32. And now moving on to another very interesting article and very important article, that is Article 142. This is an inherent power vested with the Honorable Supreme Court. And to my knowledge, I could not find any parallel power vested with any of the courts, any of the high courts. What does 142 say? 142 says, the essence of 142 is, it is an inherent power vested with the Supreme Court, and the power vested with the Supreme Court, they can pass any orders to do complete justice. So complete justice, in my understanding, it includes timely justice. Timely delivery of justice is a part and parcel or integral feature of Article 142. Therefore, this is most important. Timely justice is taking guidance from the preamble, justice, social, economic, political, then taking guidance from Article 14, Article 21, Article 32, Article 142. We can very well say, with the pronouncement, with the assistance, with the guidance from the Supreme Court pronouncements, that is in Keshavananda Bharati case, Husainara Khatun case, in many other catena of judgments, we can safely conclude that timely justice is the heart and soul of the Constitution. So with this, I am completing my second question.